As noted, the Planning Act is the primary piece of legislation in relation to land use planning, but it works hand in glove with the Municipal Government Act and a range of other pieces of legislation. In many cases, legislation will require municipalities to be consistent with or no less stringent than the provincial standard. The Planning Act contains two sets of regulations currently, the province-wide minimum development standards regulations and the subdivision and development regs. As the name suggests, the province-wide minimum development standards regs apply province-wide, while the subdivision and development regulations only apply to those areas under provincial planning jurisdiction. There's one exception to that, and that would be the special planning areas under the subdivision and development regulations. Those do apply regardless of whether or not the municipality is the planning authority. However, those regs specifically list the areas that are subject to those additional rules. It's worth noting that there were amendments approved in 2016 to the Planning Act, but those amendments have not yet been proclaimed. Once they take effect, there will likely be additional regulations specifically related to municipal planning standards, the content and process for developing official plans and bylaws, and some of the planning tools. Under the Municipal Government Act, there are a series of areas that interact with the planning process in terms of how meetings are held, how council is expected to meet standards of transparency, and likewise the regulations under the MGA would touch on access to information and protection of personal information, which would then affect some of how information is shared under the Planning Act. Other amendments or other pieces of legislation that also interact with the Planning Act would be the Water and Sewerage Act, which looks at municipal utilities, the new Building Codes Act, the Highway Signage Act, Highway Traffic Act, Cemeteries, Environmental Protection Act, Pesticides Control Act, Roads Act, and the Real Property Tax Act. And each one is slightly different in the extent to which a municipality might deal with it in relation to planning, but they're all worth keeping on the radar. Councils may not take decisions or authorize actions that are prohibited under provincial or federal rules. Watercourse setbacks would be an example of this. Even though the province sets the standards, municipalities may not approve an action that would contravene them. So even where the standard is not a municipally established one, the municipalities and council are bound by that. Many municipal planning documents integrate those provincial standards into their own bylaws in order to ensure that they are in compliance. Municipalities, however, may be more stringent in their rules. Other requirements that come into play at different stages in the planning process, such as requirements for environmental impact assessments, highway access approval, and civic addressing, will come up from time to time. Signage under the Highway Signage Act is an interesting one, where in some cases municipalities do not have the authority to regulate signage. So it's important to check the regulations to determine whether the municipality has been exempted from those provincial standards. And if you are not exempted and do want to regulate signage, you need to work with highways, with tourism and the bodies responsible for the Highway Signage Act. Conflict of interest standards under the Municipal Government Act is a very important consideration, and it's actually one of the more frequent examples of when situations of conflict of interest may arise for a council. So it is important to follow the Municipal Government Act, including the processes and requirements, and these considerations would also apply to staff and contractors, so that the person making the decision is not involved in the application itself. And I would note that in the roles and responsibilities session, there was a discussion of the tips and guidance for reading and interpreting legislation, and in the legal session there were considerations about conflict of interest. Appeals to the Island Regulatory and Appeals Commission, IRAC, are the primary route available to those who are unhappy with a planning decision on the part of either the minister as the provincial planning authority or the municipality and council in areas where the municipality is responsible for land use. If the appeal is in an area where IRAC has jurisdiction to hear the complaint, IRAC will review the process followed and look at a range of criteria. They look at whether or not the municipality is acting within an area where the municipality has jurisdiction. They will look at whether or not the council or the municipality failed to consider the official plan or planning principles when making the decision that is being appealed, and they will look for errors in process. Generally, IRAC will support a municipality if the plan and bylaw have been followed and council gives reasons. It is a good idea to follow IRAC's decisions as they establish standards and precedents over time. And these orders can be found on the IRAC website. Reviewing them from time to time will help municipalities understand how the standards are being interpreted and how specific cases might be viewed if an appeal is filed. It's very difficult for municipalities to avoid appeals entirely, but if you follow proper steps, you minimize the risk of having a decision overturned. And those technicalities can matter. It's also sometimes difficult to reconcile with the desire to provide for good planning in a community, but jurisdiction is key. So if it's not an area that the province has authority over and as a result has not delegated to a municipality, then the municipality can't act within that area. So again, as with any other topic, it's important to start with the question of, do we have the authority to regulate whatever the matter at hand is. IRAC will also look at good faith. Did council proceed in a way that was fair and consistent, making sure that it's not a decision that was punitive against a person. It's important that a decision includes or is targeted at the use and not the user, and that the authority and language and process is clear. The IRAC decisions do help understand the various risks and minefields that might be out there. So again, it is important to check them out. You will see, especially over time, that the IRAC orders begin to speak about standards such as the use of sound planning principles, looking at items of, whether the decision is focused on the use and not the person, understanding of planning principles, the impacts of the decision, and all of the other criteria that are meant to be considered during the review of an application and the taking of a decision. It is critically important for councils and staff to give reasons for decisions, including through staff reports, making sure that minutes are clear. And so while often minutes are not intended to be a literal transcript of the meeting, it's important to record who was present, the nature of comments that might have been received from the public if it's a public hearing type of meeting, and as council deliberates on a decision, making sure that the reasoning and the factors that contributed to council's decision are included in the record, and that the decision itself is very clear. All of these pieces will protect council and the municipality in terms of when an appeal is filed, but also in terms of providing a good and sound planning service to the public. Always important to know your own rules within your plan and bylaw, and not just look at the bylaw, but to also understand how the plan interacts with that document. It's becoming increasingly important to look at process and standards that are being undertaken in a municipality and the province when undertaking land use planning. IRAC's orders are increasingly showing expectations for a professional approach to land use planning, and they've reflected this in their own words about the changes over time in terms of how a municipality is making informed decisions and the processes that are being followed. IRAC also has expressed an expectation for municipalities to use professional advice to ensure that they are accessing, in the words of the orders, necessary expertise to deal with the issues for which they are responsible. So when it comes to development control, that often includes the trained development officer, making sure that the person who is administering the plan and bylaw understands the scope and the responsibilities and the ramifications and all of those different aspects of their role. And then when it comes to more complex files, the drafting of policy amendments and the bigger applications, that a registered professional planner is also involved. The Municipal Government Act does apply to planning practices, except where the Planning Act is more specific. So it's important to be clear about privacy and public information, including disclaimers on forms regarding the use of information that is being collected, being clear about how personal information is protected, and that includes the discussion in public, what's recorded in minutes, and what is disclosed to the public. And being clear about what that you're sharing the information that you are actually required to share under the Municipal Government Act and the associated regulations about access to information. There are expectations and standards in those regulations about providing information on permits, for example. It's important to be consistent with the records that you maintain. Many of the records are legal or have legal implications and will have a long-term impact on the ability to understand previous decisions when a new one is being requested. So that includes everything from file numbers and permit numbers, making sure they're established and recorded, having checklists for process and for file contents, and thinking about the long-term information needs. So even where you're able to dispose of records, keep track of what you need to know in the long term, often through a database or some sort of custom software, so that again you can have access to them when you need. But it also take time to look at the records to determine whether they are legal or have legal implications, therefore have to be held on to in the long term. There is one other requirement for public disclosure, and that relates to the requirement under the Planning Act to provide public notice of decisions. This is mandatory, and it can result in extended appeal periods if this step is missed. So this is any decision under the bylaw that a council or municipality may take, including denials of an application, amendments, variances, permits, anything along those lines where it's an application under the bylaw. There is a requirement to have those decisions posted within 7 days on a website as well as in a location in the municipality. And the province has a website called PEI Planning Decisions, and municipalities have the option of posting using that system so that it's all in one place. If you have a volume of approvals that is slightly higher and it makes manual entry of decisions complicated, then you do have the option of putting it on your own website, and several municipalities have opted to do that. If you do use your own website instead of the provincial one, it's a good idea to let the province know so that the provincial website is updated to direct members of the public to your site. Again, if this step is missed, then it can have an impact particularly on the appeal period and how the time is calculated. But the expectation is that the public with the right to appeal has the right to know that there's a decision that can be appealed. There are resources out there for municipalities, and it's a good idea to take advantage of them. Planning often involves steps that you will only take occasionally, especially if your volume of applications is lower, and it can be hard to remember the steps and the processes from time to time. Do follow the checklists that are either provided by the province or the ones you develop for your own internal procedures. Missing steps can result in a requirement to start over. Some of those steps are critical, and so you want to be as streamlined and have as smooth a process as possible. There's also a range of handbooks and guides through municipal affairs, including amendment handbooks and the development decision guides, and these are quite handy to follow in terms of understanding the process. As always, rules do change from time to time, so do check in occasionally with the provincial website or municipal affairs to understand whether there's any changes to legislation or regulation. You may have printed out the documents, but they may no longer be current, so again, check in periodically. And other provincial rules or procedures may have changed, or even just how interpretation evolves over time. And this is another benefit of seeking professional support to ensure that you are getting the best advice and taking actions that comply with current standards. So this wraps up this session on land use planning in municipalities on behalf of the Federation of Prince Edward Island Municipalities. But there are other sessions in this series, and you're invited to check them out and understand how the various aspects of municipal governance and operations interact with each other and how that feeds into the land use planning process.